Court calls the case ESA Management versus Elizabeth Kurtz.
Good afternoon, Your Honor. Crystal Herm is appearing on behalf of plaintiff ESA Management for Extended Stay America.
Elizabeth Kurtz, you can stand right up here. Hello. All right, where are we on this case? I think we were at 630750 last time or something along those lines.
First of all, if I can say something.
Yes, ma'am.
I work hard. I live outside of conventional housing. I was laid off about 10 years ago. And since that time, I built a business. It's a street business where I sell street paper. And I don't receive any state aid, government aid, Section 8 or anything like that, but I have been able to maintain housing, especially after the extended stay. I don't have any representation because the legal aid system really doesn't support or represent who are staying in hotels, because the Michigan law is pretty vague on hotel stays when it comes to tenants. But I would extend stay. It is a hotel that gives you, after 30 days, it gives you tax exemption. And
You were supposed to file a written answer.
okay, I understand that. Actually, I did. And I sent it to you. I mailed it to you. And today I recognize that it had gone to the wrong email. And I have documentation for that.
You emailed it to me?
I sent it to you, but I didn't know it was rejected until I was preparing today, shortly before I was preparing today.
Okay, did you get it to counsel?
It's in my phone, it's in my documents.
No. You sent something to the court. Did you send?
I sent it, but it didn't arrive.
Okay, not my question. Not my question. Did you send it to opposing counsel?
Who was opposing counsel?
Counsel for the plaintiffs.
I wasn't aware that I needed to do that.
Oh, forget.
That's what bothers me. I live outside of conventional housing. It's hard enough to stay afloat. There's not a lot of legal representation. I haven't put together everything.
Ma'am. Yes, you're gonna have to put it together on your own. We're giving you resources to contact. You can contact the University of Michigan. You can contact whomever.
Sir, I contacted the University of Michigan. In past cases, they were unable to represent me, specifically in a case like this. Legal aid does not represent.
So you're gonna have to represent yourself.
Absolutely. That's why I'm here.
Then I need a written answer.
Okay.
And it needs to be sent to opposing counsel.
Okay. Can you give me additional time to do that? Because I can't do it here because I don't have.
What is the monthly rent?
Actually, it varies, and that's the reason I'm here, because I'm supposed to get my tax deduction after 30 days.
Counsel, what is the monthly rent?
Your Honor, it's on average 84 cents a day. And at this point,
I'm sorry, you broke up there. It's how much per day?
$86.44 on average per day. And it is the outstanding balance as of today, August 30th, is $9,539.
Yeah, I have had gradually the fees that have been added into the account. I pay much more than 84 a day. I have a receipt here that for
Ma'am?
was $1,083, and that doesn't represent a lot.
Ma'am, I'm going to need you to give in writing all of your defenses to this action. A copy of that answer needs to be sent to counsel for the plaintiff.
I have received that address today to where it's at.
It should be on your pleadings that you received?
I received a summons and I received a notice to quit. A vacate, notice to pay rent or vacate premises.
Okay,
Uh,
and do you see where it says plaintiff's attorney?
So if you.
Okay, look on the left-hand side, look on the right-hand side,
On the summons or on the.
on the summons, at the top.
Yeah. I see the plaintiff's name. I don't see necessarily a phone number. There's no email.
For Pete's sake. Hand me your paperwork.
I don't see any email. I'm glad to be. I didn't.
Right here. There's a phone number, there's an address. You can call them, you can get an email address that you can send it to them. But you need to file an answer. You need to file an answer and you're operating on borrowed time. Counsel, I apologize for this. I would ask your opinion on this, but I'm gonna do it this way anyway. You need to file an answer by September 5th.
I appreciate it, Troy. But you know, it really bothers me that people in my situation are given the short end of the stick on every.
On what short end of the stick have you gotten on this case? Tell me one that you've gotten here.
I don't have representation.
Ma'am, I've given you a week to get representation. The very fact you could not find it doesn't put you on the short end of the stick. I then told you that what you'll have to do is you'll have to represent yourself. You said fine. So I'm telling you how it's going to run. You are not getting the short end of the stick from anybody in this courtroom. And I resent you saying that about what happens in this courtroom, because anybody that comes into this courtroom doesn't get the short end of anything from this judge. So I'm done even addressing that. You will have an answer into the court to opposing counsel by the 5th. I will set a next hearing in this matter for September 6th, 2024 at 3 p.m. I'm also going to order escrow to be paid at an amount of $86.44 per day, payable every 7 days to the court.
And why am I representing myself, sir?
Excuse me?
Why am I representing myself?
Why are you?
Yes.
I don't know that I can answer that.
You can't, because there's no legal counsel available for me in this state. So that's what I mean when I say I'm getting short of it.
The escrow that you have to pay to the court must be paid in cash to the court. You can take it to the front window. They'll be more than happy to take it and give you a receipt for that. Pardon?
Okay. I'm unable to pay escrow today.
Ma'am? I ordered that escrow will be paid in the amount of 86. Do not interrupt me again. Escrow will be paid in the amount of $86.44 per day. It is due and payable to the court every 7 days. That's my order. I'll see you guys next week. Thank you, counsel.
Yep. Okay. Go! Will you hand me my screen box? Now go preach!
TDM of Monroe versus Amanda Manning.
No counsel on either side.
No counsel on either side. Your name?
Kevin Reppert. TDM.
Okay, your name. Okay, did we go through this the last time? What is TDM?
It was just a company that was set there. Me and my mother owned the property. We discussed that.
Yeah, but was it? I usually have a note on that. Was it an LLC? Was it an assumed name?
Yes, sir.
Was it an assumed name registered with, was it in Washington that it was a, okay. I'll let you go ahead. I knew we had come to some conclusion, but let me see that. All right, I granted the motion to set aside the judgment. Where are we now, folks?
I called court yesterday because the guy told me, so she still owes me $2,300.
I paid him $1,200 on July 19th.
Right, August came in, so it's still the 20.
I have $1,200 in escrow for August's rent, sir. And I have $800 that may be coming from services, which is I discussed with Mr. Decker previously and with works. But they will not release the funds until I let them know that the rent is still lifted.
That the writ's been lifted. Oh,
I think that would be
until,
$100.
well, hold on a second. And when they say the writ's lifted, what do they mean?
Like, let them know that I'm not being thrown out of the house.
You're not being thrown out. I mean, the writ, I don't know, did he even file a writ?
He did.
I did.
After I gave him money.
Hold on, hold. Stop. Everybody. Just looking for the writ. He did. That was on July 26th. But I set aside the case, the judgment, so we're at square one in any event,
Okay.
in terms of adding it up. So I don't know what
She still owes me
they,
$5 in back rent, and starting Sunday, it'll be $5.
you done? Are you done interrupting me? The folks that are giving the additional money, what do they need?
I just need something showing them that this stuff has been set aside, even if it's saying that we're starting at square one of what I owe. That's when they'll help me with the $800.
Okay.
I would.
If they need something, you can tell them to email and we'll provide something to them indicating that they're writ. Okay. So as we sit here today, how much, I must hate asking, how much do you think you owe through
Well,
August?
without them helping me with the 800, I would say $1,000. Well, 1,005.
$1,005.
That's without them getting the money from social services.
Without the money from social services, you owe $1,005. I'll come back to you. Hold on. I'll come back to you in a moment. How much are you saying she owes as of today?
$2,305 with the court costs you said I could charge last time.
I just asked for a number.
Sorry, Your Honor. I'm trying to be sure that that's okay. I'm not trying to, I don't want to smash something.
Like words? All right. So it seems to me that the distinction between the two, your figure did not include.
That what you have in the escrow.
Why is everybody finishing my set? Am I talking that slow that people have to interrupt me today? Alan, you have not interrupted me all day. I know. I don't know why everybody else can't learn. Okay. So here's the magic of this. You're saying 2305. You're saying 1,005. You have 1,200 in escrow. And gee, look what happens, people. You guys are only $100 off. You guys have said more than $100 worth of words I did not need to hear since you've been up here. So you need to get so once they know the 800's there, and then that means that I'm still 205, maybe 305 short. right? You can pay that today? You have that in cash or?
I have both the ATM, but.
Okay. So how much can you put into escrow today?
Whichever you, I don't know if it's 205, 305.
Why don't you put 305? All right, and that way we're there. What's the monthly rent? 1,200?
Yes, sir. Yes, sir.
All right. So now, what's your plan for September?
I can have it by next week.
So you can have September by next week? All right, so let me just say. If you put that amount in escrow, then by next week you'll have the September rent you can put in escrow. If I adjourn this out a week, we can come back. This whole thing can go away where it's dismissed. I release the escrow to you once we agree on a figure and we're done. Does that sound like something that can happen, folks?
Yes, Your Honor. Yes, Your Honor. Could I ask this one thing?
Sure.
She's been having fires on my property.
She's been having what?
Fires on my property. I don't have insurance for that.
That was the thing. I'm not had a fire. That's like in.
Who the heck is Mike and Kim? Who? Okay, people. All right, listen. There are fires on your property. You're saying you didn't do that.
It's a duplex, there's another apartment up. They have fires like every other day. I've never had a fire on there.
Is that your tenant? The other people in the duplex or? Huh?
Yes, Your Honor.
Okay, so did you talk to them about the fires?
Neighbors saw them and
Saw,
the day the fire occurred, the only time I saw it happen, because where I had a fire, it's a 3-acre property, they were off. It's not on a separate parcel
okay,
where the fire is. They saw our children out there that evening, there was quite a few of them, and they had.
how old are your children?
I have a 15-year-old, 14-year-old, 11-year-old, a 10-year-old, and a 9.
They're attracted to fire. I mean,
If they went out there,
they would have seen the fire and they would have headed toward it. That's that's just kids. That doesn't mean she's doing it. She's represented in court. It's not her doing the fires. It's your other tenant. So that's who you need to go talk to. Okay, so you're going to put. What are you're going to put 305. Is that what we decided? Yes.
Yes, Your Honor.
305 into escrow. Okay. And then the 800 would be coming through. And then we should be sure on that.
Tuesday morning.
And then you're going to put your September rent, which is, what did we say it was? 1,200 plus 1,200. What day would you put that in?
I can get on Friday, so it'll be on the 6th.
On the 6th. Okay, by the 6th. Okay. And then I'll adjourn this to September 6th, 2024 at 3 p.m. So get that into escrow. Put the September plus the other money into escrow before that point, so we know it's there. Then we can get this case. Thank you, folks. Everybody have a great weekend. Lisa Reppert versus Leon Brown and Melinda Brown.
Yes, ma'am. Or I'm sorry, Your Honor.
It's okay.
I'm Lisa Reppert.
Okay, that's an unnamed iPad. That's Ms. Reppert. And I see Leon Brown. You're at the 14A. You're in Saline.
Yes.
Okay, sir, you need to unmute, Mr. Brown.
Okay, yes, I'm Leon Brown. I have a letter from my wife with power of attorney. She has my 2-year-old grandson right now. She signed and dated it.
Okay, you're good. And I
Okay,
take it that is Melinda Brown is your wife.
yes,
Okay, all right, real good. Okay, this is a termination of tenancy claim. And I guess, was there a lease on this premises?
yes,
There was no written lease. There was an oral agreement.
Your Honor.
Yes.
I have a problem with that because I signed a 5-year lease with option to buy. My wife's a pet groomer and she got a percentage of the grooming and we were gonna open boarding for dogs and she was gonna get a percentage of that. I signed for me and my wife and she signed and dated it, but she didn't give me a copy of it. So now she's lying that there wasn't one. And at the beginning, I told her I could not rent a place like that because I needed to move her out, move us in, redo everything. And I couldn't rent because I couldn't do all that work and then have to move in a month or whatever. So we did a lease agreement on paper that she didn't give me a copy of. That's what she's going off of now, that the person that I signed this with isn't her. It's all been lies and fraud, my whole tenancy. And I got
Okay, hold on.
okay. So I didn't even know if this was real. I didn't even know if this was real, if it was fraud.
Okay, so hold on. To the Repperts, are you claiming rent or you want possession of the premises?
Possession of the premises, order of eviction, and money damages.
Okay.
And Your Honor, in relation to the lease that Leon is talking about, he has a propensity to exaggerate and distort and claim things at a much later date.
All right. We can stop that now because I'll just assume everybody's a liar and we'll go there. Okay? So we'll just work from that perspective. I'm not going to listen to all of that. I'm looking to make sure that all of the paperwork. Okay. So there's a problem here. The notice to quit that you given the court or that was served on them on July 8th, or so it says, is a non-payment saying that they owe $1,500.
That's correct. In addition, he owes consumers propane.
Okay, all right. But then I have another notice, but I don't have the court copy. I have another notice saying that you're terminating his tenancy, but I don't have the court's copy.
But he has a copy.
That would tell me how long a period in time you gave him. But regardless of that, I then have a health hazard. What are you? That was served on 7/25. All right. And then the only complaint I have is a termination of tenancy complaint. But I don't have a proper notice in the file.
A notice for what, Your Honor?
Pardon?
There was a 30-day notice to quit that was sent on June 20th, 2024. There was a 7-day.
June 20th.
Yes, sir.
With a letter.
I don't have that.
That was filed.
It was filed with the complaint.
Okay, I'm gonna tell you what I've got, because you've got a lot of paper in here, most of it unnecessary. I have a demand for possession, non-payment of rent that was served on July 8th. Purportedly served on July 8th to Mr. and Mrs. Brown. That's a 7-day notice for non-payment. That says he owes $1,500. There's then a lot of other paperwork, not a statutory notice. I then have a demand for possession, termination of tenancy due to unlawful drug activity. That was served on July 31st. I have nothing to indicate any drug activity, but whatever.
I have exhibits that I can show you.
Ma'am, you're telling me what I have in my file. I'm letting you know what I have in my file. So I have those 2 notices. I then have another notice. This is crazy. Demand for possession, damage, health hazard to premises, which was served on 7/25. So I have that notice. I then have, along with a bunch of other paperwork, I then have another notice that indicates that it was served on June 20th, saying that they had to move by August 3rd at 5 p.m.
That's the 30-day notice.
That's the 30-day notice.
That was supposedly served by first class mail on June 20th.
Correct.
That's correct.
And then I have a termination case. So I have all of these conflicting notices. So which one are you trying to proceed on?
I want the judgment of possession. I want the termination of tenancy, order of eviction with money damages.
Oh my God. Okay. That was not an answer to my question.
I'm sorry.
Here's the thing. I'm going to.
Your Honor, can I speak?
No.
Okay.
Because right now, this paperwork is all a mess. Because I have a non-payment of rent. I've got all of those other notices in. Even if I ignore all of those other notices, and I'm not sure that I can because they overlap. I then have a termination of tenancy that it's terminated, claiming that he's a trespasser, which I don't know how that would even be applicable. But then I have terminated by notice to quit, and I presume you're going on the June 20th notice to quit. But he's saying he's got a lease.
Your Honor, if I may interject.
Who are you?
Pardon me?
Who are you?
Okay, I'm her father. I'm the one that delivered the papers to Celine. And I delivered the papers. They were date stamped on July 13th. At that time, there was a big stack of papers. There was a complaint filed for non-payment of rent. There was a complaint filed for damage to the property. And there was a complaint filed for recovery of possession. Approximately a few days later, my daughter got a call. She was in Nashville, that the paperwork was filed wrong. And so she asked me, since I live in Toledo, to go down there and straighten it out for her. When I went there, they told me I had too much paperwork, that I didn't need the complaint form for the non-payment of rent and for the complaint also for damages to the property. So I had to rip those out. And the clerk there said the exhibits or the attachments that we had to the complaint for recovery of possession would be satisfactory. Concerning those different terminations, he was given a 30-day notice on,
Sir, I have no idea what the clerks may have told you.
you have no idea what?
I don't have any of that stuff.
Well,
What
Your
I
Honor,
have is a complaint for termination of tenancy. That's the only complaint I have.
okay. And I have copies of the original complaint that it contained all three.
I don't know how you would do all three, but okay. The only one that I have is a termination of tenancy.
Well, that's the most important.
Your Honor, can I speak?
Go ahead,
I
briefly.
have already been forcefully terminated. They have came to my house uninvited, arguments after arguments, traumatized my grandson, my daughter. My son is mentally ill, under treatment. He just got dropped off at the house by the state of Michigan, DHS, and they had the driveway blocked and the house wide open. And it has been a nightmare. And I've been out since July 29th. I've been out of there, but I've been trying to recuperate my property. But I can't do that because I keep having them pull in uninvited. You're supposed to have a 24-hour notice. I've had the.
Why are you going to the property?
Because the grass has not been cut. I'm getting complaints from the township and the neighbors about the amount of junk that's being dumped on the land, the amount of boats that were stored on the land. And he had stopped cutting the grass. So that's why we went onto the property to get the grass cut.
Did you block the driveway?
No, it's a huge driveway.
It was blocked, Your Honor. My son is mentally ill. The Department of Health and Human Services had to take him to a gas station where I could pick him up because he was scared to go there. I mean, he's really under intensive care. And this is all a smoke screen because she's committed fraud with the banks and was using that address.
Objection, Your Honor.
Was using that
First of all, that's irrelevant
Honor,
to an eviction.
Your Honor,
You guys
this is
are
a
something
smoke
else.
screen. She's got problems with the bank. They wouldn't accept my payment. They wouldn't accept my payment or let me open an escrow account because of her fraud.
That objection, Your Honor. That's completely false.
Were you there? Were you there?
I'm sorry, this is the case where that attorney reached out from like out of state asking you. This is that case. So my understanding is they weren't talking to an attorney.
Who?
Last name was Sanders.
Who was talking to him?
I believe it was something like that.
Was having an attorney represent them?
We received an email from
Yeah, but I don't have anything.
the house. I was just
Okay. Oh, that's the one. Okay. All right, folks.
So I have already been evicted. I will not step foot back on the property.
Well, they're claiming a whole lot more, so I don't know what's going on. I'm going to set it for a final settlement conference, September 10th, 2024 at 9 a.m. at the 14A1 location. Everybody needs to be here in person.
Your Honor, can I have
Yes.
Can I have time to get an attorney? Because
You have time. You have time, sir. You can get an attorney anytime between now and the 10th.
She's using her father as an attorney, and I believe that he doesn't have a license.
Okay. Well,
Your Honor, if I may speak, I'm her father. I am an attorney. I am licensed to practice in Ohio. I did make an attempt to get temporary admission to practice in the state of Michigan. I had a sponsoring attorney lined up. At the last minute, he backed out. I tried to find another sponsoring attorney. I called the economic disaster unit or recovery unit.
Sir, we received all of that information. You
Okay,
can't proceed as a licensed attorney without temporary admission. They gave you the process by which you'd have to do that.
that's right.
That's right. So I am acting pro se, and my father is here as my agent and my witness.
Okay. You guys like to use a lot of big legal words and have no idea what they mean. So here's what's going to happen. Understand this. Everybody needs to be in my courtroom September 10th, 9 a.m. in person. Sir, if you want to get an attorney, you have plenty of time between now and then to get an attorney to represent you on the matter.
Thank you so much, Your Honor.
Thank you, folks. September 10th, 9 a.m.
Can I just say that I have been evicted and I will not be back at the property?
Well, I don't know what you're saying. All I'm saying is I'm not making any ruling. Everybody needs to be here September 10th, 9 a.m. Anybody got anything else? You really probably don't want to say anything else.
Thank you so much, Your Honor.
Great. Everybody have a wonderful holiday. We'll see you on the 10th. Whitaker Oaks versus Anthony Williams. It's okay. This is Whitaker Oaks versus Anthony Williams and Christina Williams. Okay, on this case, Miss Williams showed up in my court. I don't know what day. Pardon? All right, it was Tuesday. It seemed like so long ago. We had been contacting plaintiff's office because although she didn't know that the writ had been posted, the writ was scheduled to be posted. It got posted actually while she was at the court. We were trying to find out the balance, not just due under the judgment, but the full balance to bring her current after some running around. We finally got the balance. I think it was, I have my emails, 22 something.
I have 22, 29, 16.
22, 29, 16.
That's right. That balance is not.
Excuse me? Are you sure? Okay. Where's my email?
I believe it's underneath the prompt. It should be underneath the prompt.
So my question is this. There was a judgment that was taken. So why wouldn't that be included in the court costs?
Judgment I had was from June 28th, and there were court costs in there, $200.
Yes.
So that ledger, I'm not sure if you received just a ledger, or if someone from our office told you that included court costs, but the ledger I had has actually.
Oh, that doesn't work that way. I issued a judgment for a particular amount. Her ledger then, as of June 28th, should have read that amount. If it read that amount, it included the $214 in court costs.
It did include the court costs, Your Honor.
It what?
It did, that judgment did include the court costs.
I know. So why is the balance that we received not in, you're saying doesn't include court costs?
Your Honor, I'm not sure why that balance that you received did not include court costs. I know that the ledger does not include court costs in there. The ledger is from the property and we had the court costs.
So if she went in to redeem and paid the amount that was on that ledger, you're telling me that that would not have paid her judgment off?
Well, she went into redeem after the court hearing, should be advised that total amount of the cost. The ledger that I have is not to legal fees or court costs.
I don't even know what that means. If she went in after the judgment's entered to pay the amount on the to pay your client, you're going to tell me that the amount she would have been given would not have been the amount that would have redeemed the judgment?
No, Your Honor, I'm saying that the ledgers that we had. Okay, so to answer your question, Your Honor.
Okay, let's start there. Go ahead.
She would have received the judgment that'll have an amount that doesn't include court costs, yes. So if she wanted to redeem that, she would have an amount that would include court costs if she had paid the judgment on time, correct?
Okay, so where'd the court costs go?
Not sure, Your Honor. No,
Okay, I'm not sure is not it. Because here's what happened. She comes in, she says she has the money. She posted it here. She has a $500 money order to pay the entire amount that we were given by your office.
Okay, I understand, Your Honor.
But now you're coming here, we're here today, and she paid with her $500 plus what she's posted in escrow. She has that full amount that we were given. And now we get here today and you're telling me there's another $214.
Your Honor, I believe the error may come from our end, whereas the balance that was sent to you was incorrect, so that is our fault.
Oh, I know. If it is a fault. Because it's certainly, there are three of us here. Two of us, it's not our fault. So how does she redeem?
Well, Your Honor, this is a real, she failed to pay the judgment on time. And that judgment was from June 28th, July, and August fines accrued. I understand that there was some order on Tuesday where she was asked to fix a certain amount of escrow. She did it. I did speak to her in the hallway. She did tell me she has additional $500 money when we're ready. However, Your Honor, there was a red issue. So,
The writ has been issued, but since it is my order, that writ has also been stayed. I think at that point you go checkmate.
sure.
Yeah, oh, I am extremely aware of that. And when people come into my court, I just ask that they do the right thing. So if we got to try to make sure that the right thing happens, I'll call the rest of your cases and you call your client and we can figure out exactly what's going to happen with Miss Williams because she's not leaving here today until this is resolved. Miss Williams, have a seat. We'll call you back up. Court calls the case Whitaker Oaks versus Anthony Williams.
Definitely, Your Honor. I believe that's not the evidence.
Your name? Okay. So what have we decided?
Your Honor, we have terms. This one has indicated to me that the court is currently holding $1,740 in escrow.
I am.
And she also indicated that she's holding the money order of $500.
She is.
She stated that she could drop that off today. I would ask the court to release the funds if possible today. And she's willing to do that. Should be able to.
And that will satisfy the case? So her balance, so that we're clear, her balance as of September 1st, or actually August 31st, will read zero.
The balance, once this is paid, will be zero.
Any questions?
Yeah, I do have a question, Your Honor. Now, I have a zero balance. That is okay for me to go and sign my lease now, correct? Because she would not allow me to sign a new lease without a zero balance.
I can't speak to that. I'm sorry.
Boy, No, I know, Council, and I don't know what to tell you because that's typically not before me. So you'll have to. So I'm going to indicate balance will read 0. Defendant's balance will read 0. Release, escrow, all the escrow to the plaintiff. And the plaintiff should be getting a back check for that $1,740.
You have orders on other cases that I attended today.
Oh, that you did? Yeah, if you could give them to my bailiff, we'll attach them to the file and I'll sign off on this. Thank you. You're welcome. Have a great weekend. Good holiday. Representative of Ricky and Travis Brown State versus Melanie Brazen Sanders.
Everyone's into.
Good afternoon,
Also
Your Honor.
state your appearance. Go ahead.
William Gross here on behalf of Ashley Brown, or the estates, really.
Who else is here on this?
Melanie Sanders, defendant.
All right, where are we on this case, folks?
Your Honor, last week we had our initial hearing, and at that time, you'd asked that my client provide her letters of authority, showing that she is the personal representative for both the Ricky and Travis Branham estates. We've submitted those to the court. I believe they're in the case file. So at this point, we'd be ready to proceed to the full hearing.
All right, ma'am, what do you have to say about this case?
So on July 1st, I was given the notice to quit. On July 10th, I paid $3,000 for a home for us to be removed from the estates per her wishes. I found out after the 10th that was scam and I got scammed. I took that to the Jackson Rentals Associates and figured it out. That's a whole different court case that I am dealing with on my own, which is why I don't have a lawyer for this case, because the other case kind of has a little bit more priority. I informed Ashley that I would not be in the house on August 1st, but she could drop off the eviction notice. Instead of just taping it to the window, she and her party proceeded to enter the dwelling through my 10-year-old autistic son's bedroom. Doing so, there was some damage to his belongings. There are also some things of my son's, like his laptops that are for school this year. He is homeschooled, that are missing. His entire life savings that was on our pellet stove is missing. And I have expressed to them that I am working as fast and efficiently as I can to get us out of the home. I am just requesting at least 3 more weeks to figure out my situation.
Counsel, you know anything about your clients entering the home?
I'm sorry?
I don't. I believe she's here and may be able to speak to that. I understand that she did at one point arrive at the home hoping to, I don't know, get back possession. I think she misunderstood the time frame of things. But I was not aware of anyone entering the home.
Did she enter the home?
I believe she's available here now.
Turn on my camera. My name is Ashley Branham, and I did not enter the home. I was at the home. I mean, there was a note that was on the door about if somebody needed to talk to an adult, to reach out. I was not aware that Melanie was even still there, but with that note on the door, we did call police for 4 hours that day to try to get somebody out there just to do a wellness check. But then after we had left the property is when I guess all of that transpired.
Did anybody with you? If you didn't go in, did anybody with you go into the premises?
My sister did.
Under what authority did she enter the premises?
Well, we had called the police for 4 hours that day, and they said, well, if it is your residence, like they advised that if you're the legal owner of it. So, I mean, nothing was taken. We did not.
You may be the legal owner subject to their leasehold.
She doesn't have a lease, sir. She is not paying rent. She has not made any.
Your Honor, I believe
I
there was.
really don't have time to give you the legal definition of that, so I'm not going to. I'll let your lawyer do that for you.
Okay,
Thank
well, I
you,
mean,
Your
I'm
Honor.
just saying she never had a lease. She was with my brother.
Yes, and Ashley.
Well,
we
that's
can-
a problem
we can
if they
discuss
enter the
this.
premises.
Yeah, Your Honor,
That's a
as soon as
huge
I
problem.
became-
That's counsel. That's a huge problem.
Yeah, Your Honor, I was contacted, I believe, on that day by my client, and I advised her to leave the tenant to her quiet possession of the property until this matter was resolved through the courts. So I believe there was just a misunderstanding by my client.
Yeah, I've never been through this process. I didn't know. I thought the letter to acquit was the last thing, so I just was unaware. And I mean, I live 700 miles away, so I'm in Georgia. I was just trying to get some resolution to the problems that are happening, and then that didn't happen. So,
as far as I know, the tenant has been left to her quiet enjoyment of the property since that date. And
yes,
no other
but it was interrupted, counsel. That's a whole other claim.
Pardon me?
That's a whole other claim she has as against the landlord. You can't just go in.
I did call the police after I returned back to the premises after my work shift. I did have my neighbor who has video surveillance of the conversation between Miss Branham and part of her party that was there on that day, along with a whole different slew of things that I had talked to that officer about. Which again, that is a whole different case that I'm working on getting the details on for that.
Okay.
But for this case,
Yeah, I know.
I've just been,
all right, look, we're gonna have to get this resolved. So here's what I'm gonna do. I'm gonna set it for a final settlement conference, September 10th, 2024, 9 a.m. All of that is in person. All the parties need to be present before me.
That was the 10th at 9 a.m.?
Yes, sir.
All right, and Your Honor, that's another settlement conference. That's not the eviction hearing.
It's a settlement conference. Well, counsel, you can do it that way or not. Your client or somebody on your client's behalf illegally entered these premises. She has claims which she's raised before this court, claiming damage to certain property.
Sure. So I just want to know what type of hearing I should be preparing for next time.
Prepare for a final settlement conference. It's a hearing before we set a trial, if we have to set a trial. I'm going to try to resolve the case, but I think you probably need to talk to your clients about what their legal obligations and responsibilities are, because quite frankly, they're probably in a whole lot of trouble.
Is there anything the court needs us to prepare in order, like, for that
No,
hearing?
I got it. I got all. You can prepare anything you want for me, but I'm good. We'll see everybody on the 10th. Thank you.
Thank you, Your Honor.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am?
No, today.
Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, after today, I'm sitting up here, I'm the one that needs a drink.